Hello and welcome to Government with Dr. Turner. Today we will discuss the role of Congress and the Constitution in establishing the judiciary. The idea of an independent judiciary, as created by the founders, was unique at the time of our country's founding. Today, the federal court system has 3 court levels, including 94 U.S. district courts, 13 U.S. circuit courts of appeal, and the Supreme Court. Not just any case can go to federal court. Cases can be heard in the federal courts if they involve federal laws, treaties with other nations, or the Constitution, if the federal government is a party, or if a civil suit between citizens of different states involves more than $75,000. Most cases are heard in state courts. Jurisdiction describes the extent of a court's power and authority. Original jurisdiction refers to the court with the authority to hear a case first. Courts of original jurisdiction are the courts that are responsible for discovering the facts in a controversy and creating the record on which judgment is based. Appellate jurisdiction is the authority to hear appeals from a lower court's decision. Appellate jurisdiction for federal courts is all federal cases and cases originating in state courts that raise a federal question. For example, an appellant may assert that his due process of law was denied. The right of due process is the right of every person not to be treated arbitrarily by a government official or agency. In addition, in criminal cases, defendants convicted by a state court may request a writ of habeas corpus from a federal court. A writ of habeas corpus declares that the government must show a legal cause for holding someone in detention. Although the federal courts hear a small fraction of all civil and criminal cases, their decisions are of critical importance for American society. Lower federal courts include 94 district courts. They are staffed by judges according to workloads. Their routines are the same as those of the lower state courts. That is, one judge is assigned to each case. There are 13 federal courts of appeals. The United States is divided into 11 multi-state circuits, plus a separate circuit for the District of Columbia. There is also a specialized court of appeals for the federal circuit, which has a jurisdiction over certain types of cases rather than a certain geographic region. Roughly 20% of all lower federal court cases are reviewed by the 13 federal courts of appeals. In courts that have appellate jurisdiction, judges receive cases after the factual record is established. Ordinarily, new facts cannot be presented before appellate courts. Decisions made by these multi-judge courts are usually final, except for those cases selected for Supreme Court review. Because the Supreme Court has the power to decide what cases it will hear, it generally deals only with matters of national importance. The Supreme Court is America's highest court. Article 3 of the Constitution vests the judicial power of the United States in the Supreme Court. The court is made up of a Chief Justice and 8 Associate Justices. The Chief Justice of the Supreme Court presides over the court's public sessions and private conferences. The size of the court is not set by the Constitution. It can be changed by Congress at any time. Article 3 gives the Supreme Court 2 types of jurisdiction: original jurisdiction and appellate jurisdiction. Although the Constitution gives the Supreme Court original jurisdiction in several types of cases, such as those affecting ambassadors, most original jurisdiction goes to the federal district courts. The Supreme Court is the only federal court established by the Constitution. The powers of the Supreme Court listed in the Constitution are not clearly spelled out. The lower federal courts were created by statute. Congress can restructure or presumably even abolish them. Federal judges are nominated by the President and approved by the Senate. Federal judges' terms consist of life appointment until death, resignation, or impeachment. Let's review. The idea of an independent judiciary as created by the founders was unique at the time of our country's founding. The powers of the Supreme Court listed in the Constitution are not clearly spelled out. Most civil and criminal cases in the United States fall under state jurisdiction. The vast majority of the cases that are heard by the U.S. Supreme Court come to it through their appellate jurisdiction. Federal judges' terms consist of life appointment until death, resignation, or impeachment.